As a women's rights activist, as a lawyer, and a change agent, my job really in Malawi is to try and influence policy reform and legal reform for the betterment of women in my country. Basically, if you look at Malawi, you find out that we have a constitution. The Constitution of the Republic of Malawi is a highly progressive legal document. It guarantees gender equality, it guarantees women's rights, and it guarantees rights for special interest groups. So it is a good constitution. So why am I relevant in my country? Because if it guarantees women's rights, it guarantees gender equality, I should not have a job. But basically, the other side of it is that Malawi is generally a patriarchal state. You find that women generally occupy a subordinate position. And in this regard, one of the drivers of this patriarchy is culture. Now, why would culture exist whilst you have such a progressive constitution? You see, a constitution is a form of a received law. Basically, what I'm trying to say is state law lives side by side with the ordinary customs and practices of our system. So basically, state law derived from the colonial rulers. When they colonized Malawi, just like so many sub-Saharan countries, they brought with them what is now called statutory law, our own state law. But it doesn't mean that when colonial rulers came in, we didn't have our own laws and customs. They continued to go on side by side with the state law. And today, in 2013, that situation still obtains or is still happening. Now, that is what is called legal pluralism. When I first submitted my concept to the organizers of this conference, I talked about legal pluralism. It's my favorite topic. I live it, I drink it. It fascinates me as a lawyer. Because when I was in law school, I was taught the law is the law is the law. When I started working, particularly in the areas of women's rights, I realized the law is not the law, it's not the law. There exist other, subcultures, customs and practices that are complementing with the law. And that just, brightens me up. That just gives me fire because I really am very interested in this particular notion or priority of the legal system. But then when I gave them the concept note, they wrote back and said, blah, 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 this is good and this and that. But Seodi, don't use the word legal pluralism. It's too technical. And I sort of laughed. I laughed, particularly to myself. I'm like, do they know that being a Malawian, to use the word pluralism, it is such a challenge. One word has L and R. And I'm gonna dare use it in a public forum. It is an achievement. I'm a Malawian. So here I go, legal pluralism. I did it. One of the ways in which legal pluralism plays itself is also through the construction of laws which continue to be subordinate to women. One such law is the Wills and Inheritance Act, which has since been repealed in August 2011. When I started my activist work in 1998, and I looked at the books of the law and I found out there's this law called Wills and Inheritance Act, and when I looked at it, I was like, ooh. I found that it was a highly oppressive piece of legislation. In a nutshell, that law provided that if a man, and I'm using the man in terms of man, like not man as it also means woman, no, man. It talked about if a man died, his estate was supposed to be given to his children, his spouse, and his relatives, and the law actually said even more remote descendants of the deceased person. And when we worked it out in my organization, we said, actually, the even more remote descendants, could be 10, because, we have, our extended family system structure in Malawi. plus the children, plus the spouse. So it meant that the ones who were supposed to benefit from the deceased estate could be about 20. So let's say a man leaves property worth or money worth $2,000. It meant that $2,000 had to be equitably shared between the even more remote descendants as well as the widow and the children. This law, we called it a dispossessing tool. It dispossessed the widow. It dispossessed children. And we decided to go around the country to lobby and advocate with parliamentarians and other policymakers to change the law. That was 1998, 1999, 2000. And it was very interesting to talk to policymakers, to talk to parliamentarians, and they'll be like, yeah, Seodi, you know, now that you're presenting this, you're saying the law, you know, the Constitution and the law, they're not tallying, because that was the basis of our argument. To say, when you look at the Constitution of the Republic of Malawi and this law is repressive and it is going against the letter of the Constitution, therefore we must change it. But in order to change it, it has to go back to the parliamentary floor. So fine. They said, yeah, you know, it's true. Okay, there are two things we need to take into account. One, when you are changing this law, parents of the deceased person have to benefit. And the figure that kept coming up was 25%. They have to have beneficial interest of 25%. Because in our culture, we believe that if you raise a child to a point where the child becomes very successful and the child dies, a parent has to benefit something because they worked very hard. And this is a very strong sentiment among Malawians. You can't change them. I don't have a problem with that. The other issue was, yeah, but Seodi, you know, now these women, you know, the point is you women, Malawian women, are scheming. You are sneaky. You are evil. Because if you know that by the time you get married, when your husband dies, you have the right to inherit all your property, or the property, or your marital property, you accelerate the death. Because traditionally, women are responsible for cooking. You just put poison in the food and feed your husband in order for him to die so that you can get the property. So that debate raged on for 13 years after that. I wish I had said 2 years, but it raged on for 13 years after that. Anyway, we continued advocating until in November 2010, the matter went to Parliament. And it was debated on the parliamentary floor. Even for it to reach Parliament, it was a huge success. But anyway, so we were very excited. We said, that's it. 13 years of work have paid off. The law is finally going to change. Women are going to be entitled to the work, to the property that they've worked hard for. And then on the parliamentary floor, I had the shock of my life. Because there they were. I would not even mention the MPs, but they know themselves. They're the way, this law goes against the fabric of our culture. We cannot allow women to inherit their property because they will kill their husbands. And when I was thinking, I thought, it can't be true, really. And they sent that legal document back. The bill was sent back to the Parliamentary Committee on Legal Affairs saying, can we take a look properly at this, because women are killers, sneaky. This was 2010. We've been working from 1998. It hurt me. It shocked. I said, what did they say? They said they've sent it back because what? We kill, we are killers. So their wives are killers, their daughters are killers, all of us women are killers. Basically, all we want is to property, to kill. We have no other purpose but to kill for property that we work for. I was hurt. And that day, I had a choice of resigning. In fact, I said, I'm resigning. I said, what am I resigning from? I'm an activist. Whatever forum I find myself in, I'm still an activist. So I couldn't resign. So, but I was very angry. But then I decided we have to go back to the drawing board and keep advocating. And in August 2011, the law was passed. And it recognizes women's rights to inherit and their children only, with a very small percentage for the parents. Everybody happy? And it's a good document. That was one of the happiest days of my life. But then I talked a little bit about the law being a dispossessing tool. I talked about that coming from the contextual framework that basically in our culture, remember I said the law competes with culture. In our culture, we have a practice called dispossession of the widow. Some call it property grabbing, but Women and Law in Southern Africa, the organization I work for, we coined the term dispossessing the widow. And what happens is that in the cultural construction of Malawi, when a man and a woman get married, they're not related. They are just married. And they are related to their people. So you say, like, his people come and, her people come. But so when they come, they're like, we have come to visit ours. Yes, hello, but this one. So what happens, like, let's say the husband dies. So let's say he was a CEO. His relatives will come in and say, hello, widow, sorry. But we are here to assess what did our person leave. He was a CEO, he had 2 cars, this house, and blah, blah, blah. And they'll look at her and say, anyway, you were not very rude to us, so we'll give you a cooker. But even then, maybe we're quite nice. We'll give you a car. If you're given a car, you should be very thankful. So they give you like a car. The rest they take because our person worked very hard, and this is what he acquired. See ya. That is what is called dispossessing the widow. And that continues to this day, despite a very progressive legal document, a very progressive law that I've outlined before, that was passed in 2011. There's still that tension, that competition. I still get cases in my office where they say, I was dispossessed, Seodi, please help me. I'm like, but the law has changed. I said, you know how it is. So then as I was thinking about this, I said, there's something about widowhood in our culture that we don't like, or that people like to play around with. Because that's not the only culture that you have to deal with. The other culture you have to do is widow cleansing. In the southern tip of the country, Women and Law in Southern Africa, we conducted a research in 2009. And what we found out was that widow cleansing is a culture whereby when a husband dies, the widow is supposed to cleanse the spirit of her dead husband from her so that she does not get bad luck. And how that is happening is that you get a man from the village who's a well-known cleanser, who is visited by the family to say, please come and help us. We need to be cleansed. And he charges. In 2009, when we calculated, it was 7,000 kwacha, and that was $50. And we talked to some people. And this continues to this day. Because some people say, but Seodi, because people are scared of HIV/AIDS, this has changed. I was like, it has changed. We found this practice, and we even talked to the people involved in 2009. 2013 is no longer there. In fact, what worries me about the widow cleansing culture is we have even driven it underground because it is now becoming more and more stigmatized. But then at the same time, people still believe that they have to be cleansed. So I believe it is still there, and I'm sure if I took my car and drove there, we'll find it, as a researcher. So then what bothers me is to say, to what extent, therefore, can we have the law that can change? You cannot regulate everything, sadly. But at the same time, you can promote policies, programs that eradicate harmful cultural practices like dispossessing widows, like widow cleansing. We need to continue coming up with legislation that is responsive to the women's rights agenda as per our constitution, because the women's rights agenda is not something that is just dreamed up. It is entrenched in the Constitution of the Republic of Malawi under Articles 20, 24, and 30. So that responsive legal framework should also be encouraged, that there should be programs supporting implementation of the law, programs supporting women's empowerment. But more importantly, why is a woman like me, I'm a Malawian, I was born in this country, but the bottom line, why aren't I faced with those challenges is because I went to school, because I'm educated. There is need to invest in education. There is need to invest in girl education. There is need to fight practices like child marriage, which are encouraging girls to stay out of school. There is no sense of emergency. There is no sense of urgency about girls' education, and that bothers me. And I would like to invite you to hold my hands so that together we can make sure that our girls stay in school so that they can become someone like me. Thank you.